Mr. Butler.
My lady, my lords, yes, my name is Butler. I appear on behalf of Mr. Kulkarni with my learned junior, Mr. Hugh Rowan. My learned friend, Mr. Jonathan Crowe, KC, who did not appear below, represents the first respondent, leading his learned junior, Mr. Thomas Braithwaite. The second respondent, to which I shall refer as Newey, is not represented before the court.
Yeah.
I was proposing, my lord, to begin by saying a few words about the facts that led up to the making of the shareholders agreement with which this appeal is primarily concerned. I'm conscious, of course, that the court has the benefit of a lengthy and detailed judgment and also a synopsis in our skeleton argument. And I don't want to take time telling the court what it already knows.
We have all read the judgment.
I'm grateful.
So I think you can essentially go straight through to the issues rather than spending time on the background.
I'm very grateful, my lord. In that case, I will move straight on to the shareholders agreement of the 13th of February 2020. That can be found at page 244 of what I'm going to call the core bundle.
Yeah.
That was page
244, my lady. And again, what I'll do, again, subject to the court's guidance, rather than just launch straight into the grounds, I'll take your lordships and your ladyship through what I say are some of the key provisions of the shareholders agreement, and then what happened afterwards, very briefly, before returning to develop my submissions, if I may. So the shareholders agreement is made between three parties, Mr. Kulkarni, Gwent Holdings Ltd, and Newey. And the first part of the agreement, which I should draw the court's attention to, can be found at page 246, under the heading Background, where the court will see two statements, well, three statements.
Sorry, do you mean 247?
I'm sorry, 24.
Sorry.
You're one page behind us.
Or are you, the electronic version is one page out, is it?
Well, my lord.
Background is at 247. In the hard
247. I will have to update all my page references by one.
It may not be so simple later on.
It may not. So under background, three statements, the first two of which are relevant. First of all, the statement as to the issued share capital. At that stage, 3,370 A shares. And the statement there below that each initial shareholder is the registered owner of the number of class shares set out in Schedule 1, to which we will come in due course. Moving on then into the agreed terms, there are two definitions to take the court to, which merit particular consideration. At the bottom of what I think will be 248, there is the definition, first of all, of excluded shareholder, which is each shareholder whose proposed course of action is a subject of the relevant shareholder consent. And then at the bottom of that page, shareholder consent, which is the prior consent of the majority of the holders for the time being of the A shareholders, excluding where relevant any shares held by an excluded shareholder. And the concept of shareholder consent obviously surfaces in clause 7.1d and elsewhere in the shareholders agreement, where the involvement of a particular shareholder or category of shareholders is conveniently to be excluded. If we move on then into the body of the agreement, excuse me, we come to clause 3 on page 251, which was the clause, breach of which was pleaded in the particulars of claim. The company shall not take any of the actions set out in Schedule 2 without shareholder consent. And then clause 4, each shareholder shall use his reasonable endeavours to procure, and then certain words in parentheses, that the company shall not take any of the actions set out in Shareholder 2, and we'll come to Shareholder 2 in a moment. Moving on through the shareholders agreement, we come then to clause 6, which deals with the transfer of shares. This is towards the bottom of page 251. And there are a couple of clauses to have regard to here. First of all, clause 6.6, which is in a few lines down on page 252, provides that if the seller serves a transfer notice or deemed transfer notice within 3 years from the date of this agreement, then the transfer price shall be restricted, and a choice of 2 possible prices is given. It's a maximum of the lower of the subscription price paid and the fair value of each share. And I draw the court's attention to that just to highlight the time limit of 3 years, which makes it important to know when a deemed transfer notice is served. Very significant consequences could flow from it. And then clause 6.7, which I think my learned friend would want me to draw your attention to, which deals with the withdrawal of a transfer notice. It limits the circumstance in which a transfer notice may be withdrawn by the seller, but then it's the last words that my learned friend would highlight. A deemed transfer notice may not be withdrawn. Moving further through the agreement, I don't think there's anything else I want to take your lordships to in clause 6, which runs on for some pages. But if we then come down to clause 7, which is the compulsory transfer provision that we're primarily concerned with on this appeal, it provides that a shareholder will be deemed to have served a transfer notice under clause 6.4 immediately before, and then there are 4 events: the shareholder's death, the presentation of a bankruptcy petition, the shareholder lacking capacity, which I suppose we might read as ceasing to have capacity, if we want it to be an event, and finally the clause we're particularly concerned with, the shareholder committing a material or persistent breach of this agreement. And then the words which were the subject of a particular argument at trial, which, if capable of remedy, has not been so remedied within 10 business days of notice to remedy the breach being served by the board acting with shareholder consent. So just pausing there, the effect of that is, as we've seen from the definition of shareholder consent, that the board cannot serve a notice unless the shareholders who are to give shareholder consent, which is all the shareholders apart from the excluded shareholders, consent to the board taking that course. But what the shareholders who give consent cannot do is force the board's hand. They cannot direct it to serve a notice. And I say that's of some significance when we come to consider what this clause means and how it's intended to work. Clause 7.2 then provides that a deemed transfer notice under 7.1d shall immediately and automatically revoke a deemed transfer notice under the other clauses. And then if we move down into clause 7.3, I draw the court's attention to 7.3e, which provides that the seller does not have a right to withdraw the deemed transfer notice following a valuation. And I think that is broadly consistent with the clause we looked at earlier, 6.7, that says that a deemed transfer notice may not be withdrawn. Moving on through the agreement, clause 8, now on page 256, deals with the valuation of shares. I don't think I need trouble your lordships particularly with anything in that clause, or indeed the clauses following 9, 10, 11 or 12, all the way down to 13, which is on page 261. Now, clause 13.2 confers on the holder of any A shares the exclusive right to appoint a director as an A director at all times during the continuance of this agreement, and then provides for the right by notice to the company to remove and replace directors so appointed. And that obviously is relevant in the context of what the parties refer to as the Hussein breach. We then come to clause 16.1. I'm now on page, what I think will be the court's page 263, at the bottom of that page. This is another of the clauses on which reliance was placed in the statement of case. Each shareholder shall, to the extent he's able to do so, exercise his voting rights and other powers of control lawfully available to him as a shareholder to procure that provisions of this agreement are properly and promptly observed and given full force and effect according to the spirit and intention of the agreement. And breach of that clause was pleaded and indeed admitted. I think we can now move fairly swiftly through the rest of the body of the agreement. There are the sorts of provisions which one might expect to find in an agreement of this kind. Clause 22, no partnership or agency, that's at the top of page 266.
And 19, entire agreement.
And 19, I'm very grateful, my lady, that was the other one I was going to take you to. I thought it came after, but it comes before, as your ladyship helpfully points out. And then we can move on to the schedules, which begin on page 269. And the court will recall that Schedule 1 is referred to in the preamble, and that schedule provides that Gwent has 1718 A shares and Mr. Kulkarni has 1652. That was not, in fact, the case at that time. The position was that Mr. Kulkarni had one and Gwent had no shares. The other share in existence at that time was held by Mr. Andrew Francis, who was a colleague of Mr. Kulkarni's. And then Schedule 2, over the page, deals with matters requiring shareholder consent. And paragraph 3 is relevant and appears in the statement of case, increasing or reducing the amount of the issued share capital. And then paragraph 4, permitting the registration of any person as a member of the company other than pursuant to an allotment or transfer permitted or required by, made in accordance with this agreement or the articles. And again, breach of that clause as regards the A shares breach and the B shares breach was pleaded and admitted. Now, I'll return to these clauses in the course of developing grounds 1 and 2 in particular. And I'm conscious that your lordships and your ladyship have read the judgment. I'm wondering, therefore, to what extent, in the same way that I've passed over the events leading up to the making of this agreement, I really need to trouble the court with events after it. Perhaps what I can do, and again, I'll be moved on if I'm telling the court things it already knows, perhaps what I can do is just move on to the breaches so that the court has firmly in mind the dates on which they were committed and their longevity.
Yeah.
So the key dates here are, first of all, on the 21st of August, and the court will have well in mind the events that took place in between the making of this agreement in February and the 21st of August.
And this is 2020, isn't it?
And this is all 2020. Yeah. Essentially, Mr. Andrew Lewis, who had come in to take over management of the hospital, had made efforts to regularise the shareholdings with Mr. Kulkarni and other consultants. Of course, COVID-19, which looms in the background of this case, had broken out on the 20th of March, and Mr. Kulkarni, who was identified as vulnerable, had self-isolated. And there were then some communications, all of which are referred to in the judgment, about Mr. Kulkarni's hopes and expectations as regards shareholding and other matters. And on the 21st of June, of course, Mr. Lewis wrote an email which is the subject of particularly scathing criticism in the judgment, in which he relieved Mr. Kulkarni of his employment, his directorship, and also made what was called an offer, but which the judge says was not really an offer at all, in relation to the shareholding. And I can see that the court has obviously read and has cognizance of the judge's comments about that email. And there was then this period of well, negotiation might be too strong a word, but essentially Mr. Lewis trying to implement the agreement that he considered, wrongly as the judge held, had been made, with the sending of repeated share transfer forms and essentially deadlines being given to Mr. Kulkarni to sign those, failing which the offer, as he described it, would be withdrawn. And against that background, on the 21st of August 2020, the first of the breaches is committed. Gwent procured on that date that Newco should allot to it, first of all, the 1,651 A shares, which were Mr. Kulkarni's entitlement, and secondly also 2,000 B shares, and furthermore allotted 1,235 B shares to other consultants. So that was the first breach. On the 28th of August, Gwent then purported to terminate the shareholders' agreement. The reference in the court's bundles to that communication is a supplemental bundle at page 148. Perhaps I could just ask the court to turn that up, if only to check that my information in that bundle is correct. So
28th of August.
28th of August, I hope
Yes.
the court has at page 148.
Yes.
This is the termination. The middle paragraph refers to the fact that the termination is purportedly on grounds, and I should describe it really as a purported termination rather than a termination. Our termination is on the grounds that the agreement is based on a fundamental flaw, namely that the initial shareholders included Mr. Kulkarni owning 1,652 A shares in the company. By contrast, he only owned 1 A share, and he did not properly subscribe for, nor was he issued with the additional 1,651 A shares. So that is the termination breach. So by the 28th of August, we have 3 breaches committed: the A shares breach, the B shares breach, and the termination breach. There is then something of a hiatus. Mr. Kulkarni at this point in time has been peremptorily relieved of his employment, his directorship, and his entitlement to a substantial shareholding in the institution. He spent a few months picking himself up, but then in May 2021, solicitors instructed by him wrote giving notice of the appointment of Mr. Hussain. In your lordship's bundle, that can be found at page 270, still in the supplemental bundle. Letter of the 21st of May. And the notice of appointment, which is dealt with at towards the end of quite a lengthy letter, begins at page 63 on page 278. And at the back of the letter, the court will find, this is now on page 281, a signed formal notice of appointment. That elicited a response which I think can fairly be described as a doubling down on the part of Gwent. If I could take the court onto page 298 in this bundle. The court should there find a letter from VWV solicitors dated the 10th of June 2021. This essentially rejects the appointment of Mr. Hussain. And if I could draw the court's attention particularly to the paragraphs at the top of page 300, the court will there see the heading, the SHA, and a reference to recital 2 that we've looked at. And in the following 3 paragraphs, essentially an allegation of fraudulent misrepresentation on the part of Mr. Kulkarni. Said he signed the SHA knowing that this was false. He also signed it knowing that he either did not have the means to subscribe for the shares or was unwilling to pay for them. The court will be aware, of course, that it was Mr. Kulkarni's position that a promise had been made by Mr. David Lewis to pay for them on his behalf, and I don't need to tell the court how that played out at trial. The letter goes on to say that Gwent entered into the SHA as an external investor and as a non-director. It didn't therefore know that your client was being offered the shares at a preferential rate and that he was not in fact the registered owner of the 1652 shares. And then the allegation effectively of a clear misrepresentation, although it's said to be whether negligent or fraudulent, it is in effect clearly an allegation of fraudulent misrepresentation. So a doubling down in that letter of Gwent's position, now of course some 9 months after the commission of the original breaches. And this also was the beginning of the Hussain breach. The notice we've seen dated the 21st of May, that was not acted upon. And it took the involvement of solicitors for Newco to bring some reason to the situation. That letter can be found on page 313. Perhaps I could just draw the court's attention to paragraph 16 of that letter on page 315. Purported termination of the shareholders agreement, paragraph 16. The hospital accepts there was no misrepresentation on the part of Mr. Kulkarni, insofar as the hospital be deemed to have known that it had not paid any premium for his additional A shares. Doesn't make any comment on the state of Gwent's knowledge. And then in paragraph 21 over the page, the hospital will therefore proceed on the basis that the shareholders agreement remains in force and its terms bind the parties. And in paragraph 23, dealing with ownership of the A shares, the hospital accepts that Mr. Kulkarni is the rightful, legal and beneficial owner of one A share. The hospital will treat him as the beneficial owner of the remaining 1651 A shares, which should have been allotted to him and were instead allotted to Gwent on the 4th of June 2020. And then dealing with the appointment of Mr. Hussain from paragraph 27 onwards, the hospital also recognise, or I should say Newco, also recognise that Mr. Kulkarni is entitled to appoint a director. Gwent then correspond a few days later on the 27th of September. A similar letter, I should say, is sent to Gwent, and that letter appears on page 320 of the bundle. And Gwent then respond on the 27th of September. Perhaps before I take the court to that letter, I should just draw attention to paragraph 34 of the VWV letter, which is on page 317, which sets out a proposed way forward in 8 numbered paragraphs. I'm so sorry, Clark Wilmot's letter, yes. Grateful to my learned friend. And that is the proposal which we will see is then accepted by VWV on behalf of Gwent. And that letter is dated the 27th of September 2021, and it begins at page 325. our client is agreeable to the proposal set out in paragraph 34 of your letter. This, I should say, is a letter sent to Clerk Wilmot. It's merely CC'd to Mr. Kulkarni's solicitors. And the second paragraph acknowledges that the SHA has not been terminated. The third paragraph then states that Gwent will return the A shares and B shares and make arrangements for their allocation on payment to Mr. Kulkarni. That way forward was then implemented. A resolution was sent out to shareholders. And there are various copies of that resolution in the supplemental bundle. I don't think I need to take the court to them. They begin at page 172. And finally, on the 26th of October, so just about a month after the correspondence we've been looking at, the buyback appears to have been completed. I take that date from page 215 of the bundle. It's an email at the bottom of that page from a Mr. Denny of Bevan Buckland, recording in the second paragraph that the A shares and B shares had gone into Treasury on the 26th of October. Although it's apparent that, and I think as everybody expected, there was then going to be a delay before the relevant document, the SH03, was processed by Companies House. And we see that from an email on the preceding page, page 214. Showing that the SH03 had been submitted, but as the author of the email, Ms. Ruffle, says, they, Companies House, are still very behind, so there will be a delay in getting this back. So leaving aside the time taken at Companies House to process the SH03, that process of the shares being returned from Gwent to Treasury at Newco took about a month. And then finally, in this part of the chronology, your lordships and your ladyship will see at page 222 that Mr. Hussain is confirmed as a director on the 11th of November 2021.
I missed the page.
222, my lord.
Yep.
On the 11th of November. So again, the chronology there from the request on the 21st of May to the 11th of November, during which time, as we've seen, Gwent doubled down on their original position until the intervention of Newco. Now, again, at the risk of just taking the court through matters a little bit too slowly, may I just finally, in this opening section of my submissions, take the court to the statements of case so that the court can see how the various admissions of material and repudiatory breach developed. This is in the core bundle. And I'd like the court please to go first of all to page 193 in that bundle. At 193, just above paragraph 49, the court will find section E. This is in the, I should say, the re-amended particulars of claim. Section E, breaches by Gwent and SJIH of the SHA. And there is then pleaded in the paragraphs from 49 to 84 the A shares breach, the B shares breach, and the termination breach. The Hussein breach is dealt with in a separate section of the particulars of claim. And that having been done, I think the court can flick fairly swiftly through those paragraphs, but that having been done, at paragraph 85, at the beginning of section F, this now on page 198 of the bundle, or I think 199 in the court's versions, paragraph 85 avers as each of the breaches of the SHA referred to in section E above were material and repudiatory breaches of the SHA. If we could then go to the amended defence, which begins at page 214, re-amended defence, I'm sorry. And look at the way that section E is dealt with. This is first of all on page 222 of the bundle. There are various averments as to the underlying facts, but in relation to the A shares breach at 32C, towards the bottom of page 223, it's admitted that in so acting, Gwent acted in breach of the SHA. So far as the B shares breach is concerned, there's a corresponding plea on page 224. At paragraph 36C, it's admitted that in so acting, Gwent was in breach of the SHA. And then in relation to the purported termination, paragraph 45 on page 226, it's admitted that at the time Gwent purported to terminate the SHA, it did so in renunciation of the SHA, which therefore amounted to a repudiatory breach of the same. And then over the page, on page 227, the answer to paragraph 85 of the re-amended particulars of claim. As to paragraph 85, it's admitted that the breaches of the SHA alleged in paragraphs 49 to 59 and paragraph 77 to 84, that's A shares and termination, were repudiatory in nature. It's denied that the breaches of the SHA in paragraph 60 to 76, that's B shares or the Hussein appointment, were repudiatory in nature. No plea there about materiality, which is, of course, the trigger under the Shareholders Agreement for 7.1d. But materiality was admitted in relation to certainly the A shares, B shares, and termination breach in the defendant's written opening before trial, not in the court's papers, I'm afraid, but paragraph 53 is the paragraph. And to the extent that breaches were not admitted by the first defendant, as the court will have seen, the learned judge held that all four breaches were both repudiatory, were both material and persistent, so as to potentially engage clause 7.1d. And again, I hope I don't need to delay proceedings by taking the court to those paragraphs, but for the court's note, it's paragraphs 6.7 to 6.9 of the judgment. That's on page 58 of the core bundle. That's the summary of the judge's findings. And then paras 424 to 426, that's page 148 of the core bundle. That's where the judge deals with the Hussein breach and also finds that the breaches were all persistent as well as material. So against that backdrop, the judge turned to consider the application of clause 7.1d. And I'd now like to move into developing my submissions in relation to ground 1 and the operation and effect we say that clause has. Let me first go to the judgment in the core bundle at paragraph 311. That is at page 127. This is where we say the judge fell into error so far as the grammatical reading of the clause is concerned. What the judge says at paragraph 311 is that where the breach is capable of remedy, the plain reading of the language of the clause as a whole is that no transfer notice is deemed served until the 10 business day remedy period has expired. That period only starts once the notice to remedy is served. Here, no notice to remedy was ever served, so the 10 business day period has not yet started to run and so cannot have expired. As such, the deeming conditions have not been satisfied and no transfer notice is therefore deemed served. Let me, against the backdrop of that paragraph, perhaps before we leave the judgment, it's convenient just to look at the page above where there's a long citation from the ABC electrification case, which I'm sure this court is very familiar with, but for my part, I certainly find it helpful to remind myself from time to time of what Lady Justice Carr, as she then was, said there. Paragraph 1 emphasises that the primary way in which the court undertakes its task of construing a written document is by focusing on the meaning of the relevant words in their documentary, factual and commercial context. Paragraph 2, which I place some reliance on in particular before the judge, says this: the reliance placed in some cases on commercial common sense and surrounding circumstances should not be invoked to undervalue the importance of the language of the provision which is to be construed. The exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader, and say perhaps in a very unusual case that meaning is most obviously to be gleaned from the language of the provision. And then to the same effect in paragraph 3 below, when it comes to considering the centrally relevant words to be interpreted, the clearer the natural meaning, the more difficult it is to justify departing from it. So I highlight those passages in that lengthy citation, all of which is important, but which the parties agreed below, and I think agree here, represents the proper approach to interpretation. And against the background of those words, I then go back, if I may, to clause 7.1d itself. That, to remind the court, can be found on page 255 of the bundle. The first question that I submit that it's helpful for the court to answer is what are the events referred to in the preamble in each case? Well, in the case of A, B, and C, I submit it's pretty straightforward. Death and the presentation of a bankruptcy petition. And then clause C, I've commented on the fact that lacking capacity could perhaps be referred to or read as ceasing to have capacity, if we want that to be an event rather than a state of affairs. And then in D, I submit that it's clearly the commission of the material or persistent breach, which is the event for the triggering of that clause. And it must be that moment of the commission of the breach, I say, for 4 reasons. First of all, as a simple matter of grammar. The shareholder committing a material or persistent breach is, I think, what grammarians call an apposition to the phrase "the following events" in the preamble. So the first reason is that that's what the grammar of the clause leads us to the interpretation that the grammar of the clause leads to. The second reason is because that creates parity with the other clauses, in each of which the event appears at the outset of the clause: death, the presentation of the bankruptcy petition, or the loss of capacity. The third reason I say it must be at the moment of commission of the breach is because the alternatives are either service of the notice to remedy, or, which is how the judge in my submission interpreted it, the lapse of 10 business days from that, the service of that notice. And both of those are conditional on the breach being capable of remedy. So that would lead to a different interpretation of clause 7.1d, or a different event, depending on whether the breach is capable of remedy or not. And that's not a natural reading of the clause. It must be a particular event, whether or not the breach is capable of remedy. And so again, I say that consideration points to it being the commission of the breach. And the fourth reason why I say that's the natural reading is this. I showed the court in clause 6.6 why this might matter. That's the clause which contains a 3-year time limit for the event giving rise to that price optionality, if you like, for the acquisition of the shares, the lower of the price paid and the fair value. So the identification of the event is important for that purpose, and it would be logically wrong to postpone the event until either the board chooses to serve a notice of remedy or the actual remediation. It would give the wrongdoer, in effect, a longer period. So for those four reasons, I say the event is clearly the commission of the breach. But that then leads to a potential problem in the context of 7.1d, because at that moment, there are matters that might still happen in the future which could cause the deeming of the agreement not in fact to have occurred. And I'll come to address those in a moment. But before I do, there is one other important semantic consideration in this clause which we say was overlooked by the judge, and that is the word within. Remedy has to be within 10 business days. Now, within is a simple English word, and we say that means neither before nor after. But the judge's interpretation in paragraph 311, to which I took the court earlier, treats that 10 business day period as effectively a long stop date. It involves reading this clause, and in particular the word within, as not later than. And it contemplates the possibility that remedy could take place earlier than the service of a notice to remedy. And we say, as a matter of the wording of the clause, that's not a permissible interpretation, because the word within is very clear. So the effect of the clause, we say, is this. It gives rise to essentially a straightforward flowchart type exercise in 3 stages. And this is set out in our skeleton argument at paragraph 40. First of all, the first question is, has the wrongdoer committed a material or persistent breach? If yes, then the clause is potentially engaged. If no, then of course it isn't. And if yes, you move on to the next stage, which is that breach capable of remedy? If it's not capable of remedy, then the transfer notice is deemed served. But if it is capable of remedy, you move on to the third stage, which is this. Has the breach been remedied within 10 business days of a notice to remedy being served with shareholder consent? And if the answer to that question is yes, then the deeming is undone, no transfer notice is deemed served. But if the answer is no, then you are left with a transfer notice being deemed to have been served. And the situation we're in, and there's no dispute about this, is that no notice to remedy was served. So we are left, on our reading of this clause, with 4 both material and persistent breaches, no notice to remedy, and therefore a transfer notice being deemed served. Now, the language of the clause, we say, is clear, but does that have to yield to considerations of commercial common sense? And on this, there are really 3 points that are made against me. The first is a problem that we acknowledge on our reading, which is that the wrongdoer who remedies ahead of time, before a notice to remedy is served, could be left in a worse position than one who persists with the breach and only remedies after the service of a notice. That is correct as a matter of a consequence of our reading of the clause, but it is a more theoretical problem than a real one, we say, and the reason is this: if the innocent party wants the defaulting shareholder to remedy their breach and their continuing participation as a shareholder, they will not complain that the remedy has predated the notice. But if the innocent party does not want remedy, then no notice to remedy is going to be served anyway, because it can only be served with shareholder consent. So while we acknowledge that is an oddity of our reading, we say that it's purely theoretical and will not prove problematic.
Okay, can I just be clear about the last part of that? So the innocent party doesn't want the wrongdoer to be involved anymore.
Yeah. In those circumstances, they won't consent to the service of a notice to remedy by the board, and therefore the board can't serve.
And unless there's service, you can't avoid the consequences of the breach.
I'm sorry, my lord, I didn't catch the first half of that.
Unless there's service of the notice,
Yes,
you can't avoid the consequences.
that's the position for the wrongdoer. But that's fair enough, we say. This is only engaged when there's a material or persistent breach. So it has to be quite a serious degree of breach. And by parity of reasoning with the position with repudiatory breaches of contract and common law, and we'll come on to this in the context of ground 2, the cure should not be in the hands of the wrongdoer.
Sorry, go on.
The wrongdoer, it shouldn't be open to the wrongdoer to commit a serious breach and then remedy it and say, well, this route is now closed off to you.
I mean, following through on your reasoning, in effect, can you dispense with all the words following which? Because the innocent party can prevent the board serving a notice. So it really doesn't matter whether it's remediable or not. If the innocent party doesn't want the wrongdoer still to be involved, all it has to do is block the service of a notice, and that's that.
Yes, but the words after which are important in this context. If the innocent party wants the continued involvement of the defaulting shareholder, then it is, or perhaps can't buy the shares, or for whatever reason needs their expertise, or whatever it might be, this is the leverage that the innocent party has. They can say to the board, we consent to you serving a notice to remedy, and that then creates leverage against the wrongdoer who, having received the notice to remedy, has 10 days to either put things right or risk losing their shares.
Well, the innocent party would have all that leverage anyway, or more. I don't quite follow what the role of these words would be. I mean, if the innocent party is in a position where he can prevent the wrongdoer being involved anymore and can get the shares, well, it's a matter for negotiation. It's that's just how it is.
But if the innocent party wants the wrongdoer to continue to be
Then all
involved,
he has to do is agree a deal with the wrongdoer under which that happens.
well, but this gives leverage to prevent the wrongdoer from continuing to commit their breach, essentially.
What does giving leverage mean?
It means that the wrongdoer faces, if they don't comply with a notice to remedy, it faces the possibility of losing their shares on unfavourable terms, particularly within the first 3 years, as we've seen from clause 6.7. So it creates, when I say leverage, I mean perhaps an incentive or motivation to become compliant, which otherwise wouldn't exist.
But it would exist.
But isn't that the situation, as my Lord Justice Newey has said, if you stop at just before which, in the sense that in those circumstances, that is, you would say, the event which has occurred, and therefore they will lose their shares at a price which is not conducive to them, unless there's negotiation.
Well, my lady...
And so the difference is that this just creates, you would say, or I assume, that the remainder of that clause just creates a clear mechanism. You received a notice, you know where you stand, and you know what the period is. Get yourself together and do what you must do or face the consequences.
My lady, yes.
So you would say that is setting out a structure and parameters.
Yes, and I do maintain the submission that it's possible to conceive of circumstances where the innocent party very much needs the continued involvement of the defaulting party, but might not have a particularly good negotiating position in order to achieve that. This creates that negotiating position.
It creates a structure and a mechanism.
My lady, yes.
Mm-hmm.
So
Can't read the clause in a different way, can you? The event is the breach, and the breach has to meet certain requirements. It has to be a material or persistent breach, and it has to have been unremedied within the relevant time frame. So the event is the committing an unremedied material or persistent breach.
well, my lord, in my submission, that gives rise to one of the problems I alluded to when addressing the syntax or the grammar of the clause. It means the event is different depending on whether you're in the confines of a remediable breach or a non-remediable breach. And that's unsatisfactory in my submission. For all the reasons that I've endeavoured to set out, the event is, we say, clearly the commission of the breach.
But it's not any other breach. By definition, if you just commit a breach, a deemed transfer notice isn't served or isn't deemed to be served. It's got to be a breach of a certain kind. What kind? It has to be a breach of a material kind or a persistent kind. It has to be a breach of an unremedied kind. I don't see why it's a clumsy way of just describing the nature of the breach.
Well, I think what your lordship is putting to me, if I've understood correctly, is that this clause perhaps wraps up two different kinds of material or persistent breach.
Wraps up a number of characteristics which a breach must have in order for a deemed transfer notice to have been served. And the characteristics which the breach must have must be, it is not sufficient for it to be a breach. It has to be a material or persistent breach. It also has to be a breach which is unremedied within the relevant timescale, assuming it is capable of remedy. It's seeking clumsily, one might think, to describe the characteristics that a breach must have in order for the shareholder to be deemed to serve a transfer notice.
Well, my lord, that would be, I would gratefully adopt your lordship's characterisation of that as clumsy, and I would submit too clumsy to possibly be the right interpretation, because it, as I say, effectively bifurcates the clause into two, material or persistent breaches which are capable of remedy and material or persistent breaches which aren't, and it provides for a different event in each case, which is the conclusion, the point that the judge arrived at. In the first case, the event is the commission of the breach, and in the second case, it's the failure to remedy the breach within 10 business days of the notice. Now, if that had been the party's intention in my submission, it would more naturally have been expressed in a different way and possibly with an additional clause. In other words, separating out the consequences for material breaches which are capable of remedy from those which are not.
Could it say the shareholder committing a remediable and unremedied material or persistent breach? Would that have been a way of achieving what I'm suggesting? Another little clause to say when it's unremedied by?
Had I been sitting down to draft what your lordship is suggesting, I think I would have included a clause E, which was effectively in the case of a material or persistent breach which is capable of remedy, the expiration of the period of 10 business days from a service of a notice requiring that remedy. Something to that effect. But we say that for the reasons I've outlined, I think I'd be in danger of repeating myself. That isn't the natural reading of this clause. I'm therefore addressing what I understand to be the objections that are laid down against me from the point of view of commercial common sense. I've dealt with the first, which is the problem that the wrongdoer who remedies quickly is in a worse position than the wrongdoer who remedies only after service of a notice. I've endeavoured to address that. The second point my learned friend makes in his submissions is that a deemed transfer notice cannot be withdrawn, and the construction that we put forward has the effect of withdrawing. That, in our submission, is easily avoided. It's really just a matter of analysis. We've seen in some circumstances a deemed transfer notice can be revoked, clause 7.2. But what we say is really happening here, the most natural way to understand this is that it's as if a conditional deemed transfer notice has been served, if you like, a deemed transfer notice nisi, which will fall away if a notice to remedy is served and complied with, and invoking those concepts of withdrawal, which appear elsewhere in the shareholders' agreement, is inapt. And this is a mechanism that the law is entirely familiar with. It arises in a variety of circumstances. We've referred to relief from forfeiture in our skeleton argument, the status of a lease that's been forfeit pending an application for relief, which may have the effect of retrospectively reviving it. A charging order nisi is the same. It's said to give rise to a security that's often described as defeasible. And in the event that the charging order is set aside at the final hearing, that security will fall away. And there are other examples one can pluck from other areas of the law. There is no conceptual difficulty, we say, in having a deemed event which is nevertheless defeasible or conditional on the occurrence or non-occurrence of a future event.
I mean, one feature of this, on your case, is there's no time limit on the notice being served.
That was the third
Yes, I see.
point that I was going to address. The uncertainty of the duration of that twilight or defeasible status. And our answer to that is that it's again more of a theoretical problem than a real one. Once the breach is committed, the cards are in the hands of the innocent party, which is as it should be. They can invoke the sale procedure straight away or at any time until the breach is remedied in accordance with the clause, subject always to considerations such as waiver or estoppel, if perhaps they wait too long. If the innocent party wants to invoke the deemed transfer notice procedure, it's vanishingly unlikely that they will simultaneously consent to a notice to remedy being served. So as soon as the breach is committed, the innocent party can move to the deemed transfer notice procedure. It is therefore unlikely that the wrongdoer is going to be left in a state of uncertainty as to how their breach is going to be treated. But as I say, if the innocent party wishes the breach to be remedied, this clause confers the mechanism by which that can be done. So, yes.
I mean, it's all very different. You referred to the LPA, Section 146. It's very different from the LPA. I mean, with the LPA, the landlord must, if the breach is capable of remedy, give that opportunity. Here you say, well, the innocent party really doesn't have to worry about any of that at all.
Well, the cards are left in the hands of the innocent party, that's true. I suppose in invoking the LPA, I have in mind those situations with which I'm sure your Lordship, indeed the Court generally, will be familiar, where uncertainties arise during the period, what's referred to as the twilight period, between the act of forfeiture and the hearing of the application for relief. And I think the phrases used in the authorities are twilight or phantom or something of that kind.
Yeah.
And we're really in the same territory here. I appreciate, of course, there are differences, but I use the analogy just to make the point, hopefully, that the law is perfectly comfortable dealing with events which may ultimately turn out to be, or deemed events, which may turn out to be undone by things that happen in the future. It arises all the time.
If you can undo the events by something happening in the future, how does that affect clause 7.2? Because if you have a deemed transfer notice under 7.1d, that does automatically revoke a deemed transfer notice served under 7.1a to 7.1c. So if the 7.1d is undone, does that revive the 7.1a or 7.1b or c notice?
My lord, if I may say so, it's a very good question. It's not one
Lucky
that,
guess.
not one that I've applied very much thought to in advance of this hearing, and not one that arises in this case.
No, but
my
it helps
submission
to work out what the wording
Yeah.
is, and if you're right to say the key is the feasibility by a future event, and if that is built into the first clause 7.1. I wonder then how it affects clause 7.2, or it might be that it's not there at all.
My submission, which is very much off the cuff, is that if the deemed transfer notice under 7.1d subsequently ceased to be so deemed because notice to remedy was served and complied with, a deemed transfer notice which had arisen under any of those other provisions would automatically come back to life. It would fall away for all purposes, I would submit. And so the deemed transfer notice, I mean, again, perhaps a slightly theoretical problem, because the deemed transfer notice gives rise to rights on the innocent party, which they may or may not want to invoke. And if they've already got the right to a deemed transfer notice under one of those other clauses, it might be difficult to see why a notice to remedy would be given in relation to clause 7.1d. But my answer to your Lordship's question is that if a notice under clause 7.1d or a breach under clause 7.1d is remedied in accordance with the notice so as to stop the application of that clause, then it's for all purposes, and the landscape is left as it would have been had it never occurred.
You're also submitting, I think, that going back a little further, Mr. Butler, that the innocent party would have matters in their own hands, because in effect they could prevent the service by the board of a notice of remedy, because it's acting with shareholder consent. But shareholder consent is prior consent of the majority, other than the wrongdoer.
Yes.
So it depends on your shareholding and whether you have that control
Yes.
or you don't.
Yes, my lady, I accept that point. it's theoretically possible in a multi-shareholder situation that some will say, we don't want this remedy, and some will say we do. And then it's just a question of what the majority of those shareholders want. But of course, even if the majority consent to the company going down this route, as I've already submitted, they can't compel it to do so. It's ultimately a matter for the board of the company. All they can do is they can stop the company from acting by refusing to consent.
Yeah.
Unless there's anything I can assist further with, those are really my submissions on ground one. It's a pretty straightforward, well, I say straightforward, it's a matter of construction.
Yes.
I'm going to move on, if I may, to ground two, which is that as a matter of law, repudiatory breaches are not capable of a remedy in any event. I've shown the court the way this is dealt with on the pleadings. It was averred that there were material and repudiatory breaches, and it was admitted that 2 of the breaches at least were repudiatory in nature. The judge didn't in fact address, wasn't asked to address, whether the other breaches were also repudiatory in nature, because what matters for the purposes of clause 7.1d is simply whether they're material and remediable. But it's admitted that at least 2 of the breaches are repudiatory in nature. Now, just to develop this ground, I'm going to need to take the court through some authorities for the first time. So if I could ask the court to take up the authorities bundle. And this, of course, as the court will be aware, was the ground on which the judge gave permission. It was obviously a point that he found problematic, as I think is evident from both his original judgment and his judgment on the permission to appeal application. So the authority that I rely on is the Bournemouth University and Buckland case, which is at page 323 of the authorities bundle. A decision of the Court of Appeal dated the 24th of February 2010, Lord Justices Sedley, Carnworth and Jacob. The facts are fairly straightforward and can be gleaned from the headnote. The dispute concerned a university professor who marked papers in a particularly harsh way from the student's perspective. The papers were remarked, and the university upheld the remarked papers without consultation with him. He argued that that was a repudiatory breach, even though, in the meantime, an internal inquiry had cleared him. And at first instance in the employment tribunal, that tribunal, without being asked to do so by the parties, considered whether the internal inquiry had cured the breach, and decided that it had not. The Employment Appeal Tribunal then considered that same question and disagreed with the Employment Tribunal, deciding that the breach had been cured. And in the Court of Appeal, the more fundamental question arose as to whether it was possible to cure a repudiatory breach and thus deny the innocent party of the right either to accept or not. Now, the key passages, other than the headnote, are really paragraph 1, if I may take the court to that. It's page 328. Where Lord Justice Sedley sets out the 2 important and unresolved questions, as he describes them. And the second is the one we're concerned with, whether an employer who's committed a fundamental breach of contract can cure the breach while the employee is considering whether to treat it as dismissal. This question is then, perhaps just to show the court a little bit more detail on the facts, if I need to do that. Paragraphs 3 on page 329 show that the claimant had failed 14 of 16 resit examinations, and paragraph 5, a little bit further down in the second line, refers to the setting up of the inquiry in mid-October. Just a little bit of colour in relation to the facts. And if we could then go down to the substance of the decision in paragraph 32, at the bottom of page 333 of the bundle pagination. Actually, I think by coincidence also the pagination in the case itself. Your lordships and your ladyship will see at the bottom of that page, B and C, can a repudiatory breach be cured before acceptance, and if so, was this one cured? And at paragraph 32, we see that the Employment Tribunal, having found a repudiatory breach on the university's part, asked and answered a question which neither party had put to it. By the time the claimant purported to accept the breach by giving notice of termination, had it been cured. Then a little further down at paragraph 35, Lord Justice Sedley, having set out the disagreement on the question between the Employment Tribunal and the EAT, says, if the case were to reach this point, therefore, I would hold that the ground on which the Appeal Tribunal allowed the university's appeal was not well founded. But the issue of cure falls to be decided in this court on a more fundamental ground, because Mr. White contends that the law of contract, employment law included, knows no such doctrine. He then sets out in the following paragraph some observations on the state of the law as understood to be. And at paragraph 39, cites from the earlier Court of Appeal authority of Stocznia Gdańska, where Lord Justice Ricks sets out the law on the acceptance of repudiation, which is well known to every law student, and affirmation, and sets out the choice that awaits a victim of a repudiatory breach between acceptance of repudiation and affirmation of the contract. And the famous phrase, writ in water, there appears. At paragraph 40, Lord Justice Sedley says that this account of the alternative courses which may be taken in response to a repudiatory breach leaves no space for repentance by a party which has not simply threatened a fundamental breach or forewarned the other party of it, but crossed the Rubicon by committing it. From that point, all the cards are in the hands of the wrong party. The defaulting party cannot choose to retreat. What it can do is invite affirmation by making amends. And then at paragraph 41 is really the meat of this particular judgment. Lord Justice Sedley says that to introduce into that relatively clear pattern of law an exception is to open up case after case to an evaluation of whether the amends constituted an adequate cure of the breach. And perhaps I can just leave the court just to read those two paragraphs.
Yeah.
And then just at the end, to conclude this passage, paragraph 44, Lord Justice Sedley says that with some reluctance he accepts that if we were introduced to employment law, the doctrine that a fundamental breach, if curable and if cured, takes the innocent party's option of acceptance, it could only be on grounds of capable of extension to other contracts, and for reasons I've given, I do not consider we've been justified in doing this. So no special approach to employment cases. Instead, he alludes to what he describes as a reasonably robust approach to affirmation. And indicates that the innocent party may lose their right that way. So this is clear authority in which this question of the possibility of curing a repudiatory breach arose and was answered in the negative. Before we leave this case, the court should have its attention direct to the short judgment of Lord Justice Jacob, agreeing with Lord Justice Sedley. At paragraph 52, I'm now on page 337. He makes the observation that he doesn't share Lord Justice Sedley's regret in holding that a repudiatory breach of contract, once it's happened, cannot be cured. once he's committed a breach of contract which is so serious that it entitles the innocent party to walk away from it, I see no reason for the law to take away the innocent party's right to go. He should have a clear choice, affirm or go. Of course, the wrongdoer can try to make amends to persuade the wrong party to affirm the contract, but the option ought to be entirely at the wronged party's choice. And that has resonance, we say, with what we say is a proper interpretation of the Shareholders Agreement, that once the material or persistent breach has been committed, the cards should all be in the innocent party's hands. And Lord Justice Jacob then goes on at paragraph 53 to say that this has been the common law rule for all kinds of contracts for 30 centuries. It works. And again, the court may wish to read for itself the rest of that highlighted passage down to the end of paragraph 53. So that is the case on which we rely. I'll come back in conclusion to the question of whether this is a false equivalence between the regime at common law and the regime in a contract. But just if I may, to deal with the authorities that are lined up against me on this point. There were two in the court below, and there are now three. And the first is the Crane and Wittenborg case, an unreported decision of the Court of Appeal, which can be found on page 162 of the authority bundle. It's the decision of Lord Justices Stuart Smith, Aldous and Mance, dated the 21st of December 1999, so predating by a couple of months the Bournemouth and Buckland decision. Now, the facts of this case were as follows. The parties were both engaged in the business of the manufacture and distribution of vending machines, and they entered a long-term agreement, Crane initially at this time being referred to as Polyvend. It became Crane on a merger. They entered a long-term agreement whereby Polyvend would supply certain types of vending machine to Wittenborg. Now, that agreement contained a termination provision, which I'll take the court's attention to straight away. If the court browses down the report, they will see at page 164 the beginning of a lengthy citation from the contract. And that goes on all the way down to page 166, at the bottom of which appears clause 15, termination. Does the court have that? And at letter B, on the top of page 167, we see the wording of that termination clause. Each party shall be entitled forthwith to terminate, I think that should be, rather than terminated, this agreement by written notice to the other if that other party commits any substantial breach of any of the provisions of this agreement, and in the case of breach capable of remedy, fails to remedy the same within 90 days of receipt of a written notice. So that's the clause that was operating in that case. Now, what happened if we scroll down? We can see the next page, paragraph 7 on page 167, the bottom thereof. The court will see that when Crane acquired control of Polyvend, it decided to discontinue the manufacture of countertop machines altogether. And to cut a long story short, this was in March or April of 1997. And in July 1997, we'll see from paragraph 11, Wittenborg wrote saying that, and it's really the bottom two paragraphs that matter, this cessation of production, in other words, amounts to an express declaration that it will not perform its obligations under the agreement. Wittenborg considers this as a clear and deliberate breach of agreement, which entitles Wittenborg to treat itself as discharged from any further performance under the terms of the agreement. Please accept this letter, etc. So the question arose as to, first of all, whether Crane was in breach at all, and secondly, whether it was in repudiatory breach, entitling termination. And the Court of Appeal held, if I can ask the court just to scroll down to paragraph 18, really, at the bottom of page 171. I think I can cut this short by stating that between paragraphs 14 to 18, Lord Justice Mance, have I got that right? Yes. Held that there was no breach. And then paragraph 19, he says, assuming this is wrong, what's the consequence of that? Fifth line down in paragraph 19, the question would thus be whether Polyven's announcement of a decision to cease production of model 1215 was repudiatory, or, to adopt the alternative word, renunciatory of the contract as a whole. And having given his reasons, he says at the bottom of that paragraph, I would therefore concur with the judge's view that if there was a breach, it was not repudiatory and could not justify Wittenborg's letter dated the 11th of July 1997. And then, for good measure, at paragraph 20, he considers a further alternative position, if that is wrong, and he held, and we see this at the bottom of page 172, that it had been affirmed by Wittenborg anyway, because of the delay between April, when the breach was committed, and July, when it was accepted. And 3 lines up from the bottom of page 172, he says, it's clear as the judge held that far from treating the contract as repudiated or at an end, Wittenberg affirmed it as the judge held. So we've got layer after layer, no breach, no repudiatory breach, and even if there was, it was affirmed anyway. And then in paragraph 21, he deals with a submission that Wittenberg was actually entitled to await an actual breach. The cessation of production was merely a threat not to meet future orders, and the submission was made by Mr. Burnton QC, as he then was, for Wittenborg, that they were entitled to wait an actual non-supply before they accepted a breach. And in the context of that, Lord Justice Mance lines up reason after reason why that submission is wrong. And reading from the 5th line of paragraph 21, he says, first, Wittenborg didn't actually claim to determine the contract for any such actual breach. Secondly, the very limited breach, which is all that can then have occurred, cannot itself have been repudiatory. Thirdly, and more fundamentally, any termination on the grounds of actual breach would have to take place in accordance with clause 15b, which we've looked at. This is so, in my view, even if the breach was of a condition or repudiatory. So at this stage, it is fair to say that Lord Justice Mance is proceeding on the assumption that a repudiatory breach can be remedied. But as we've seen, this is very far from being the ratio of the decision. And at the bottom of page 173, this is at the end of paragraph 21, 2 lines up from the bottom of 173, he says this, the requirement in the case of a remediable breach that a notice to remedy should have been given and a 90-day period should have elapsed before any termination does not persuade me that the parties must have had in mind breaches which were less than repudiatory. I therefore consider that substantial should be read as equivalent to repudiatory. Now, I think what my learned friend would take from this is that Lord Justice Mance is clearly proceeding, as I say, on this assumption that even repudiatory breaches would be caught by that clause 15b. As I say, this case predates Buckland. Nobody, as far as I can see, took the point that a repudiatory breach would not be capable of being remedied. And there were, as we've seen, several prior reasons for dismissing the claim or upholding the dismissal of the claim in any event. So while I accept that this case is perhaps consistent with the view that repudiatory breaches can be remedied, I disagree with my learned friend that it can be described as authority for that proposition. It's simply not the ratio of the case. And the same is true, as we shall see, of the other 2 cases on which he relies.
Is there a difference between curing, whatever that word means and remedying a breach. I'd have to look at the facts of Buckland again, but were they curing it in the sense of saying everyone's thought he's a harsh marker and they have an inquiry and they say, no, he's not that harsh a marker at all. But that doesn't remedy the fact that his marking scheme was overridden when it shouldn't have been overridden. What it says was, we're looking back at it now, he's not that awful.
My Lord, we'll come on to this when we start to look at remediability. I think one point that is put quite forcefully by my learned friend, and which on the authorities I have to accept, is that when you're looking at remedy, you're looking at a sort of practical cure for the future. In my submission, to answer your Lordship's question directly, there's no difference between curing and remedying in this regard. It's a point that arises in case after case. I think as one judge put it, and I'll come to this afternoon, that the finger moves and can't be unmoved, or something rather poetic like that. In one sense, it's always impossible to remedy a breach. The breach has happened. No, you can't go back in time and pretend that the breach didn't happen. So
but there's a difference between a state of affairs where you don't allocate shares and you do allocate shares. Clearly, the shares should have been allocated on an earlier date, and you can never recreate a world in which the shares were allocated.
Yes.
But the end result, somebody possesses shares.
Yes.
That's one thing.
Yes.
And I just would have to look at the facts of Buckland and whether it was that kind of something should physically have occurred. It didn't occur, but it was brought about later, or whether it's a different thing. He was slandered and said to be a harsh marker, doing students down for no good reason, and he was overridden.
Yeah.
And then it turns out that other people thought actually the students were just as bad as he said they were.
My Lord, if your Lordship, we can go back to the facts of Buckland now if it would assist, but the facts of that case were, as I alluded to, there was an internal inquiry. And on an objective reading, I think most people reading that inquiry would have thought that it amounted to an exoneration. Yeah. But Professor Buckland did not think that. And the disagreement between the Employment Tribunal and the Employment Appeal Tribunal was whether that should be considered subjectively, i.e. what Professor Buckland thought was what mattered, or objectively, which in effect would have exonerated him and cured the breach. But I think that yes, I mean, in terms of whether one's talking about cure or remedy, one is looking to what the authorities describe as a practical solution for the future. So, that is Crane, and I don't think there's anything else I need to take you to in that case. I move on to the second case, which is the next case in the authorities bundle, Woodchester. This is a case which wasn't cited below. Don't take any point on that. But the judge didn't consider it because it wasn't put before him. It's a case that arises in the context of consumer credit. And the facts were that there was a contract between the parties which provided, if I can take your lordships and your ladyships straight down to the bottom of page 183 of the bundle, you'll see the citation from clause 9.1 of the contract, which essentially says any failure to pay higher instalments will be considered a repudiatory breach. Now, what happened was that the party, the hirer served a, the party renting the equipment fell into arrears. The hirer served a notice to terminate, but got the amount of arrears wrong. And under the statutory scheme, the notice was predicated on the breach of falling into arrears being capable of remedy. Now, pausing there, it perhaps, given the terms of the contract, didn't need to be. It could have said, because this is a repudiatory breach, it's not remediable. But it didn't say that. It said you owe X pounds, when in fact the true position was that the hirer owed Y pounds, which was a slightly lesser amount. And the question arose as to whether that invalidated the notice. It's perhaps helpful to look at the top of page 265 of the report, 184 on the electronic bundle pagination, in the judgment of Lord Justice Kennedy, where he sets out the statutory backdrop of section 87(1) of the Act. And 4 lines from the bottom of that paragraph, the court will see the words, in particular, if the breach of contract relied upon is capable of remedy, the notice has to state what action is required to remedy it and within what timescale. On the next page, 185, Lord Justice Kennedy, having set out the statutory background, returns to the facts. This is at letter B, and the facts can be seen there. Swain & Co., that's the hirer, accept that in most respects the notice did comply with statutory requirements, but they contend that it had one critical flaw. It described the action required to remedy the alleged breach as payment of £879.90 by the 24th of January. In fact, as the assistant recorder held, the rental arrears at that time was £634.30. We then see at the bottom of page 185 the parties' respective submissions. The defendant's case at letter H is summarised by perhaps the 3rd line. The notice had to state with reasonable accuracy the sum of money which the hirer had to pay to remedy his breach. The plaintiff's case is then set out at page 186, letter B. And it's interesting to read the plaintiff's case because it's predicated on the breach being capable of remedy. So the plaintiff didn't take the point that because it was a repudiatory breach, it wasn't capable of remedy in any event. And the thrust of those submissions were that the notice is valid and the hirer should just pay what they say they owe, and then they'll be okay. I think that's a fair paraphrase of what the submission was. And the conclusion reached by the Court of Appeal is then set out below letter E. In my judgment, Mr. Hodgkinson, that's the counsel for the defendant, is right for the reasons he has given. And at letter F, he says, if the hirer is said to have broken the terms of the contract, the hirer needs to know precisely what he or she is said to have done wrong and what he or she needs to do to put matters right. So again, the most that can be said for this is that the court didn't take of its own motion the point that actually this is a repudiatory breach and therefore not capable of remedy. It proceeded on the assumption, which seems to have been commonly held between the parties, that a failure to pay arrears was capable of remedy. If I'm right in my view of the law, then a repudiatory breach such as this was expressed to be under the terms of the agreement is not in fact capable of remedy, and the notice wouldn't have needed to say that it was. Whether that would have made any difference to the outcome of the case is open to question, because the notice said what it said, and the question for the court was the notice a valid notice?
I mean, in the context of the protection that the statute is supposed to provide, your case would be very surprising if it were right. I mean, that would suggest that if a company sticks into its contract something saying that failure to pay is repudiatory, then provisions about requiring remedy and so on fall away.
Yes.
The company can just say, forget about it.
Yeah, I mean, there's a statutory backdrop which is clearly predicated on the protection of the consumer. Had somebody taken the point, deeply unattractive point, that this is a repudiatory breach and therefore we can just take the goods, one would have run into all sorts of problems, no doubt, about unfair contract terms and so on. All that can be said of this case is that's not the approach that the company took. They served a notice based on the ability to remedy, and the question was whether the notice was a valid notice. It doesn't take matters very much further in this case. So that's Woodchester. And the third case that's lined up against me is Force India and Etihad Airways, another decision of the Court of Appeal. This can be found at page 273 of the Court's authorities bundle. This is a decision of the Court of Appeal of the 6th of October 2010, so it narrowly postdates Buckland. I think it's the only one of these cases that does, but Buckland isn't cited in it. The facts of the case were, and again, these can be gleaned from the headnote, but in very short summary, the defendants, that is Etihad Airways, entered into a 3-season sponsorship deal with Force India's predecessors in title, who were the owners of a Formula One racing team. The agreement contained a termination provision, which again I'll take the court to right away. Page 282 of the bundle, clause 21.3.1. This is page 167 of the report, if the court is using that pagination. But at any rate, it's clause 21.3.1. Does the court have that?
Mm-hmm.
Yes.
Grateful. What happened was that on acquiring the Formula One team, the claimant changed the logo name and the livery appearing on the vehicles. The court at first instance held that this was a breach of contract, but that it was plainly remediable because the logo could be changed back. And if I can just show the court where that is dealt with in the Court of Appeals judgment, it's page 286 of the authorities bundle. This is a long citation from the judgment at first instance, and if the court looks at paragraph 73, one can see what the judge said. What appears to me to be clear is that assuming the change of name to be a material breach of the agreement, it was a breach that was plainly remediable because it could be changed back. And on top of that, the judge held there had been waiver and affirmation in any event. So the attempt by Etihad to terminate the sponsorship agreement failed. Now, the Court of Appeal took a completely different view. And there are really two different sections of the Court of Appeal's judgment that are likely to be pertinent to this appeal. The first is paragraph 84 onwards, which the court will find beginning on page 307 of the authorities bundle. Under the heading breach of contract and repudiation, the question is posed rhetorically by Lord Justice Ricks. On these facts, was Force India in repudiatory breach of the contract? I put the question in this way, since Mr. All's submission, that is counsel for the appellant sponsors, Etihad, is if Force India had committed an irremediable repudiatory breach, then the sponsors were entitled to accept it under common law, irrespective of clause 21. I think that is correct. Clause 21 upon analysis does not apply to irremediable breach, only to a material but remediable breach. No written notice is required of an irremediable repudiatory breach. Now, this is all again predicated on the premise that repudiatory breaches can, in some circumstances, be capable of repudiation, remedy. But I think I'm right in saying that the point was not taken in this case, that as a matter of law, that was not so. So in this section of the judgment, dealing with breach of contract and repudiation, we see the conclusion set out, paragraph 87 at the bottom of this page. In my judgment, the facts stated above reveal a series of repeated or continuing breaches which were sooner or later but ultimately repudiatory. I will consider below whether they were remediable. And if we then, I mean, it's all very heavily factual, this, so I'm not going to take the court through every last passage, but if the court would be kind enough to look at paragraph 91 at the bottom of the next page, 308 of the authorities bundle, 5 lines down, Lord Justice Ricks refers to the changing of the name and the abandoning of the contractual team name by omitting the names of its main sponsors, Etihad and Alder, as a clear, grave and continuing breach of its contract. And then, similarly, at paragraph 93 on the next page, in the middle of that paragraph, this is probably about 10 lines down, the court may see the words, the deliberate change of the car livery without consultation with and the approval of the sponsors was a further serious breach of the contract. And then concludes this passage in paragraph 99 on page 311 of the authoritative bundle by saying this accumulation of breaches set against this background and strategy has ultimately to be seen as a clear repudiation of the contract. So that was a conclusion in disagreement with the judge. Now, he then, beginning at paragraph 100, goes on to deal with remediability. And he says the next issue is whether these breaches of repudiation were remediable for the purposes of clause 21(3)(1)(a). If Mr. Tregear were right in his submission that a material remediable breach is not a repudiatory breach, then we're not concerned with the question of remediability at all. However, I will assume, for the sake of argument, that whether or not a material breach need be repudiatory or not, the clause is intended to and does cover repudiatory but remediable breaches. So, important to note those words. It's being assumed for the sake of argument that repudiatory breaches are remediable. He then cites many of the cases that I'll be putting before your lordships and your ladyship this afternoon in the context of remediability. But at paragraph 108, might save a little bit of time actually if we look at this now, because I won't then have to take your lordships, the court back to this. The judge, without citing the authority of Schuler and Whitman, recorded the Sponsors' Council as accepting that the authorities favour a practical rather than unduly technical test. I think that's right. The judge concluded that any breaches of clauses 4.6 or 4.7 were remediable. But then just a couple of lines further down, however, in my judgment, these were not remediable breaches. The closest analogies are with the publication of confidential information or the publishing of advertising matter not containing a party's name. One released information which should be kept confidential, the other broadcasts a product in an inappropriate way. Looking at the matter pragmatically and not technically, I think that a proper marketing campaign is, generally speaking, all of a piece. Perhaps I can just invite the court to cast an eye over the rest of that paragraph rather than take up time reading it. The memorable phrase, the marketing genie cannot be put back into the bottle, which I think found its way into the judge's judgment at one point. Now, for present purposes, i.e. whether this is in some way inconsistent with Buckland, my submission is the same. We've seen that the court proceeded on the assumption that repudiatory breaches could be remediable, but the case was decided on the grounds, and nobody took the point, on my reading, the point that arose squarely in Buckland, that a repudiatory breach is not capable of remedy as a matter of law. In any event, the Court of Appeal concluded both that there were repudiatory breaches and that they were not capable of remedy on the facts. So that matter of law did not affect the outcome in any event. The position on the authorities is this. There's one Court of Appeal authority which deals squarely with the question of whether a repudiatory breach of contract at common law is capable of cure or remedy. I say those are synonymous. That is Buckland and Bournemouth. And there are three cases in which the court have proceeded on the assumption, to one extent or another, that a repudiatory breach is capable of acceptance. But none of those three authorities stands as authority for that proposition. It's not the ratio of any of those cases in my submission. So there's no conflicting authority, and there is clear and binding authority that, at common law at least, repudiatory breaches are not capable of remedy. Now, having looked through the authorities, I return to the question of whether or not this is a false equivalence between a contractual framework and the common law position. And the way I approach this is by inviting the court just to step back and think about what we're arguing about here. The question in this case is simply whether these breaches are capable of remedy. If even one of them is not, or even if at any time it became incapable of remedy, then the notice to remedy regime does not apply and clause 7.1d is fully engaged. And what we say in relation to this is that as a matter of law, if, as we've seen, if breaches of contract are repudiatory, such as at least two of these are admitted to be, the law says they are not capable of remedy at common law. Now, parties enter a contract being assumed to know the law, and all they have done is provide in this contract that only breaches capable of remedy will demand a notice to remedy. And it's really that simple. It's not possible to say that this is a false equivalence and that somehow parties entering a contract of this kind are giving those words capable of remedy a different meaning to the meaning given by the common law. So we say it's really not possible to argue with any degree of coherence that this is a false equivalence. And we would go further and say that the law is in an incoherent state if at common law a breach might be said to be not capable of remedy, but for the purposes of a contractual regime, it can be. And finally on this, I would submit that the respondent's submission really puts the cart before the horse by considering whether a repudiatory breach can be remediable. And we would put matters really the other way by contending that if a breach is remediable, it's by its nature not repudiatory. It's in the nature of a repudiatory breach to use the terminology that it's been used in various cases over the years, that it's fundamental, it goes to the root of the contract, and so on. And we say that a breach of that gravity is by its nature not capable of remedy. And I'll come to develop my submissions on remedy in the course of developing grounds 5 to 7 this afternoon.
Can I briefly go off on a tangent? Not least because I can't remember the landlord and tenant law properly. If you found that a breach of a lease was repudiatory, then that would not be capable of remedy.
Well, my lord, I would respectfully agree, but if your lordship asks me to flag up a case either before the court or in the recesses of my mind which says that, I'm afraid I would struggle to do so. But on the theory of the law that we put before the court, that would be right. Because to use the metaphor that we've used in the skeleton argument, a repudiatory breach breaks the vase. I mean, there are some dicta in some of the cases which we'll look at this afternoon, which certainly talk about the gravity of the breach, as one would expect, being a material factor in its remediability. I'm not conscious that there is any authority that goes so far, apart from Buckland, which we've looked at, as to say a repudiatory breach is not capable of remedy.
To be honest, I can't remember my landlord and tenant law properly. As there was debate over whether leases could be frustrated, was there? And I can't remember how far there's been debate over how far you can have a repudiatory breach of a lease. But as you say, on your case, if such a thing is possible, you would expect it to be incapable of remedy.
Yes.
Therefore, Section 146 wouldn't bite in that
Yes.
respect.
Yes, and we'll be looking, I mean, some of the authorities are in the landlord and tenant context. They tend to concern rather sort of workaday breaches, such as sort of failing to paint and putting up signs when you shouldn't and that sort of thing. None of them deal with breaches of conditions of leases or other things that are described in terms as repudiatory breaches. But if I may, I'll have a think about your Lordship's question over the short adjournment and try to pick it up in the course of the afternoon.
Yeah.
Let's just look before we leave ground 2 at how the judge dealt with this in his judgment. It's paragraphs 319 to 348. It's back in the core bundle, beginning at page 126. Sorry, I got that right. Forgive me.
130.
Yes, I'm very grateful, my lady. It's actually 130. The heading is at the bottom of page 129, so we can see we're at the start of the passage. Now, all this repays careful reading, and it is clearly, and the judge gave permission to appeal on the point, it's clearly a point that troubled the judge. He goes through a lot of the submissions that I've made to this court, and indeed the submissions made by my learned friend on that occasion. But the conclusion that he comes to is really to be found in paragraphs 346 to 348, the end of this passage, where he justifies, on my reading, the difference which he finds between the common law regime and the contractual regime as being that the common law regime is concerned with the innocent party's right to go. You see that in quotation marks in paragraph 347. He says, it follows where the innocent party's right to go has been lost, there is no reason to treat a repudiatory breach.
I'm sorry, I don't see where you're reading from.
Top of paragraph 347, my lady.
Thank you, I'm sorry. Got it.
I think it must be your page 136.
No, got it.
It follows where the innocent party's right to go has been lost, there is no reason to treat a repudiatory breach in any way differently to the other breaches. By allowing the breaching party to remedy in those circumstances, the court is not affecting that right at all. The innocent party has already given it up. So the distinction that the judge drew between the common law and the contractual regime is that a common law, you're talking about a right to go. You can accept the breach and terminate the contract. Here, you're not. You're talking about a right of a different kind to set in motion the deemed notice procedure. And the judge felt that that justified taking a different approach to the contractual regime, to the common law regime. Now, we say that is a impossibly flimsy and slender basis on which to draw a distinction. Not least because, actually, in the context we're concerned with, the deemed transfer notice procedure is just the precursor to the right to go. I didn't take the court in my exposition of the contract terms to clause 15, and perhaps I should have done, but that looks at termination. And what it provides, in summary, we can perhaps look at it if the need arises, is that once the deemed transfer notice provision has, procedure has played its course and a price has been determined and the price is paid, that's one of the ways in which the contract can come to an end. So we're only one remove away from the contract coming to an end.
Terminated without all of that, though, couldn't he? If it was a common law, if it was a repudiatory breach, he wouldn't have to worry about the notice and everything else. He could just say, no, I'm not having this.
Yes, but he wouldn't then, and this arose at trial, and as your Lordship may have seen, this was something that slightly troubled the judge in his judgment. if you accept a repudiatory breach at common law, then obviously the contract comes to an end, save for certain terms that are preserved, which do not include the deemed transfer notice procedure and the entitlement to acquire the shares at the favourable price that the innocent party is permitted to avail itself of on the express wording of the contract. So leaving aside the question of whether the contract actually ousted the common law regime in any event, and there is, in my submission, a strong argument for saying that it did. After all, you've got a contract that is essentially governing the relationship between shareholders. If you're to bring it to an end, the shareholdings sit where they sit, and you just have nothing governing the relationship. What you have instead in the express wording of the contract is a termination regime in clause 15, one route to which, I mean, we can perhaps look at that. It may be helpful to look at that now. Let's find it. It's page 262 starts, I think.
Yes.
So, clause 15.2, the agreement shall terminate. And one of the circumstances under 15.1c is where, as a result of transfer of shares made in accordance with this agreement or the articles, only one person remains as legal and beneficial holder of the shares. And then clause 15.2 provides that certain clauses shall continue in force, and they're 1, 15, 17, and so on, but not the deemed transfer notice provisions in clause 6. So those would come to an end if you just accepted a repudiatory breach, and you'd be left in limbo, in my submission.
That wouldn't actually happen here, would it? There wouldn't just be one legal or beneficial holder of the shares, would there?
Well, there would have been well, now no.
Because
when the contract was made,
yes.
But now no, because obviously there are other shareholders. And that's another reason, actually, in a multi-party contract, why it doesn't really make sense to talk of accepting a repudiatory breach at common law, because other parties may not accept that breach. And effectively, that would seem to have the consequence that the party accepting would just be ousted from an otherwise subsisting contract, which would be rather odd. So we didn't, in the end, the parties agreed before the judge that the repudiatory, the common law regime for accepting a repudiatory breach, at any rate, it didn't arise on the facts of this case, because this is all about whether Mr. Kulkarni is entitled to avail himself of clause 7.1d. And the context in which, of course, I make this submission, I've slightly digressed from my original purpose, was to say that the judge's distinction that he drew in those paragraphs 347 to 348 is not a sustainable basis for distinguishing between the common law regime and the contractual regime, not least because the deemed transfer notice procedure is, as we can see from 15.1c, a precursor, or could be a precursor, to the contract coming to an end. So my position on the legal proposition underpinning ground 2, namely that a repudiatory breach is not capable of remedy, has the benefit, I would submit, of harmonising a contractual regime with the common law. It has the corresponding effect that once a material or persistent breach in the contractual framework or a repudiatory breach in the common law framework has been committed, all the cards are in the hands of the innocent party, which is where one would expect to find them. And it is not possible for the defaulting party to essentially deny the innocent party its rights by putting the matter straight before acceptance. And that is why we say, and have consistently said, that really this case came to an end at the time when it was admitted in the defence that 2 of the breaches were repudiatory. We shouldn't have needed to go further, and indeed applications were made by by Mr. Kulkarni, then represented by previous counsel, for summary judgment. That wasn't granted, and in the event we went through the rigours of a 10-day trial. But in fact, on this point of law, as on ground one, the case can and should have been disposed of on either of those legal footings. So, my lady, my lords, unless I can assist further, those are really my submissions on ground two.
Yeah.
I'm just keeping a little eye on the time. I'm making, I think, reasonably good progress. Ground three obviously falls away because permission was refused. And I therefore move on to ground four, which is the question of estoppel by deed, or contractual estoppel. Now, the first question that arises in this context, and indeed the thrust of my learned friend's submissions, are, does it actually matter? Because if you accept that in terms of gravity, the breach is the same, whether you're talking about 1A share or 1651 or 1652A shares, then in a sense, the estoppel point falls away. But it may still have some relevance in terms of remediability. In other words, what needs to be done to remedy the breach. And therefore, for that reason, I apprehend it might be said, well, you're only talking about one share here. You know, it's easy to put that right. If in fact Mr. Kulkarni is entitled to be treated by estoppel as the owner of 1652 shares, it might be said that remedy is a slightly trickier exercise. So I keep the ground alive, but with the acknowledgement that it may be that the court will feel it's not a matter that is central.
Why is it trickier?
Because Mr. Kulkarni at all stages retained the ownership of one share. In order to remedy the breach of taking the other 1651 shares that he was entitled to, it said that transferring them back into Treasury was sufficient. It might be said that a different approach needs to be taken, or that the respondent needs to go further if by the fiction of an estoppel, Mr. Kulkarni is to be treated as the owner of those shares. It might also be said, although I think it's conceded that the gravity is the same, it might be said that the gravity of taking 1651 shares that Mr. Kulkarni did not in fact own is less than the gravity of somehow taking 1651 shares that were already his. As I read my learned friend Skeleton, and as the matter was put at trial below, I don't think any particular point is taken on gravity. But on remediability, there may be an issue. At any rate, I can deal with the ground quite shortly, probably in as much time as it's taken me to put it in its context. On the law, there's one case to look at. So let me take the court very quickly to the authorities bundle to look at that. We accept that this is an accurate statement of the law. It's to be found in the very recent decision of Reeve and McDonough. This is at page, I think it's page 516 of the authority. Sorry, 506. This is a case, the facts of which perhaps don't greatly matter, but it was a property dispute. There were two deeds, a 1958 deed and a 1988 deed. And the argument was about whether the 1988 deed stopped the parties from seeking to interpret the 1958 deed in a particular way, notably by treating it as conferring a right to demolish and rebuild a property called Rose Cottage. The court can see the deeds referred to, paragraph 9 refers to the 1988 deed, the words to keep an eye on to the extent this matters are the last 3 lines, which refer to the 1958 covenant relating to the erection of additional buildings on the Rose Cottage land shall be deemed to be modified pursuant to the terms of this clause. And then at paragraph 16.2 on page 509, Mrs. Justice Joanna Smith sets out the question that arises on the appeal at letter 2. In the alternative, the Master was wrong to hold that no estoppel arose from the execution by the parties' respective predecessors in title of the 1988 deed. That was the framework in which the issue arose. I really only take the court to this case for the statement of law that is made against that backdrop, which can be found at paragraph 55 and 56. Actually, 55 to 57, I think. Just ask your lordships to read that, and in particular in paragraph 55, there's a sentence beginning 5 lines down. If the agreement is made under seal, or if consideration moves from both sides, then as long as the agreement as to the state of affairs is made with the necessary contractual intention, it will bind both sides. And we fell down on the question of whether the SHA was made with the necessary contractual intention. The judge accepted that there was a clear statement of fact as to the ownership of shareholdings, but he said that did not, the necessary contractual intention was not established.
So do you want us to read 55 to 57, or not really?
My lord, I don't think I need to
okay.
tell this court what the law is. It's there, and I think I can probably move straight to the judgment and show you how the judge dealt with it and why we say he fell into error. Let's look, please, at the judgment at paragraphs 397 to 412. This is back in the core bundle at 143. The section of the judgment, as I say, begins at paragraph, there's 144, I think, on the court's pagination, begins at paragraph 397. The judge begins by setting out the law. I do ask the court just to take note of the citation from Greer and Kettle in paragraph 400, where the judge cites Lord Russell's dicta that where a recital is intended to be an agreement of both parties to admit fact, it stops both parties, but it is a question of construction whether the recital is so intended. Now, if we then look down, one can scan read the following paragraphs. Paragraph 406, the judge deals with my then opponent, Mr. Higgow's submission that there was not a sufficiently clear exposition of facts, or that it was unreliable because of the haste with which the transaction was put together. And he rejects that answer to the issue estoppel, the contractual estoppel point. But then at paragraph 409, he says that is not the end of the analysis, however, since Mr. Kulkarni must also show that the parties intended to be bound on the basis that recital B was accurate, even though all parties knew that it was not. In this, he faces insurmountable obstacles. And the short criticism we advance of the judge is that, having acknowledged that the question of contractual intention was a matter of construction by citing what is said in Greer and Kettle, he then finds a lot of wider evidential reasons why this was not, it can't have been the party's true intention. Whether it is the party's true intention is, as was observed in that case by Lord Russell, a matter of construction. And there is quite simply nothing in the construction of the SHA which denudes that recital of the requisite intention. On the contrary, the recital is put forward as effectively the cornerstone of the contract. So the short criticism is that the reasons given by the judge in paragraph 409 for the intention not being established are all extraneous to the shareholders agreement. And that's contrary to authority because one has to look within the four walls of the contract to see whether the intention is established. We say that, to borrow from the objective bystander test, or the officious bystander, I should say, had the parties been asked at the time they intended to contract on the basis of the shareholdings as they were stated to be, the answer would clearly have been yes. And in fact, Gwent themselves had no shares at that time, so how could they have answered otherwise? So that really is the short complaint in relation to estoppel by deed or contractual estoppel. But in view of the fact that I apprehend it may be peripheral at best, I don't propose to say any more about it.
Yeah.
I then move on to grounds 5 to 7, which, as my Lord Justice Newey observed in giving permission, all address the core topic of remediability. This is obviously a fairly weighty exercise that involves going through a number of authorities. I do note that the time, I'm very much in your Lordship's hands as to whether I embark on this now.
I think let's make a start and
Very well.
see where we get to.
Okay. So I want to take the court through the authorities really as a precursor to my submissions on grounds 5 to 7. Having done that, I can then take those grounds relatively shortly. Let's start then in the authorities bundle at page 88, which is the first case in time really on this, Schuler and Whitman. Reported at 1974, appeal cases 235. A decision of the House of Lords, Lords Reed, Morris, Wilberforce, Simon and Kilbrandon. It's a well-known case, but just to remind the court of the facts, it was a dispute between some German manufacturers of panelling and an English company that had been given the sole selling rights for that panelling. And as what was described as a condition of the contract, and I'm reading now from the top of page 89 of the authorities bundle at letter A, one can see clause 7B of the contract set out there. It shall be a condition of this agreement that the respondent shall send its representatives to visit the 6 largest UK motor manufacturers at least once in every week to solicit orders for panel presses. And then the facts are set out. During the first 8 months, the respondent simply failed to do that on what was, I think, described somewhere as on an industrial scale, but it was certainly held to be a material breach. But the evidence showed, just reading below letter B, that it was treated as remediable under clause 11A1, which provided that either party could terminate the agreement if the other committed a material breach of its obligations and failed to remedy it within 60 days of being required to do so. There was also a question of waiver in relation to the early breaches, but it's right to say that visits, even after that, were not made quite as regularly as they should have been. So that was a context in which this arose. The termination clause that operated in this case, clause 11, can be found on page 101 of the authorities bundle. Yes, so if we look at the bottom of page 100, there's 7B set out in its context, and then 101 down at letter H, or G to H, there's a termination clause under the heading duration of agreement. And if I can take the court to the word 6 lines up from the bottom, provided that Schuler or Sales may by notice in writing to the other determine this agreement forthwith if the other shall have committed a material breach of its obligation hereunder and shall have failed to remedy the same within 60 days of being required in writing to do so. And the dicta that the parties, I think, both put before the court are those that then appear at the bottom of page 102. Lord Reid refers to clause 11A1 being intended to apply to all material breaches of the agreement which are capable of being remedied. The question then is what is meant in this context by remedy. And again, the court may be familiar with this, this passage. I'll invite the court just to read it to themselves. Really down to the end of the marking on page 103 of the authorities bundle at letter C.
Yeah.
And this is the genesis, really, of the what might be described as the sort of practical approach to remedy. Lord Reid identifies two possible ways of interpreting it. He says that looking at the position broadly, he inclines to the view that the breach of the obligation should be held to be capable of remedy within the meaning of clause 7, a forward-looking practical approach. The rest of the case, it is quite a lengthy decision, but I'm not sure there's anything else that this court really needs to look at. Most of the debate in the speeches concern whether the use of the word condition in clause 7 actually really meant condition, so that any breach gave rise to a right to terminate, or was just being used in a non-technical sense. Lord Wilberforce came to the former conclusion. The remainder of their lordships reached the latter conclusion, and therefore, by a majority, the appeal was dismissed. So that's the first case in time. The second case is Saba and Hussain, which is at page 154 of the authorities bundle, and this is the first landlord and tenant dispute in the authorities. It was essentially a forfeiture case. The tenant committed certain breaches, and I think in one case a trespass. The court can see those set out in the judgment of Lord Justice Staunton, page 156 of the authorities bundle, 152 of the report. There's a paragraph about halfway down the page beginning the main heads of breach with which we are now concerned. Does the court have that paragraph?
Yes.
Grateful. One can see they're of a pretty sort of workaday nature, if I can describe them in that way. Signs, the alteration of a fascia, and a flue being put through the ceiling, which I think was technically a trespass, possibly as well as a breach of the terms of the lease. And the point that arose in this case is that the Section 146 notice that was served didn't call for remedy, and therefore the question arose as to whether these were breaches that were capable of remedy. And in that context, the key passage is to be found on page 158 of the authorities bundle. In the paragraph that's marked, or hopefully marked in your lordship's bundles, beginning in my judgment. Just invite your lordships to read, and your ladyship to read that paragraph. And adopting an approach that resonates with that adopted by Lord Reed. In the earlier case, the Court of Appeal took a practical, forward-looking view. Here's where the rather poetic metaphor of the moving finger appears: rights and cannot be recalled. Lord Justice Staunton says that is not, to my mind, what is meant by a remedy. It's a remedy if the mischief caused by the breach can be removed. So that's really all I want to say about SAVA. I just would observe in passing that the breaches in these two cases that we've looked at so far, Schuler and SAVA, are of a different level of magnitude to the breaches, I say, that we're concerned with in the present case. Agreements just didn't run their course, but they're, in both instances, pretty workaday breaches. The next authority then is Phoenix Media. I wonder if I might now invite your lordship to rise. I'm going to spend a little more time on this case, and it would be unsatisfactory to leave that in mid-flow.
In which case we'll start again at 5 to 2.
All rise, please.